Welcome everyone to our panel on separation of powers, and we will hear first from Rebecca.
Super. Thank you, Maggie. Thanks to the conference organizers, and thanks as well to my co-panelists. I was so delighted to see all the perhaps unexpected ways that we're going to be in dialogue with each other. The project that I wanted to share with you explores the phenomenon of second bite lawmaking, where lawmakers return to the drawing board after suffering defeat in litigation and try again and again and often again, in the words of one federal court, attempting to change as little as possible and still withstand judicial review. Or in the more vivid language of another opinion, the government keeps crashing the same car into a gate, hoping that it might someday break through. So this might seem like a strange area of inquiry, but the impulse animating the project is that highlighting this persistence and studying it as a trans-substantive phenomenon can yield an important analytical payoff. So I had three goals with this phase of the project. First, just to describe the phenomenon of second bite lawmaking and identify the pressing questions that it raises for constitutional litigation. Second, to map out the court's guidance on these issues and to show that it has been changing. And third, to critique the recent turn. So the first goal is really descriptive. It's to identify and report on the phenomenon of second bite lawmaking, to illuminate that so much constitutional contestation is multiphasal, and to show that when we home in on this iterative quality, we can really see pressing questions that go to the heart of the substantive issues at stake. So the paradigm example here is a historical one that we're all familiar with, the sequence of relentless efforts to prevent Black communities from voting, the chronology that led up to the enactment of the Voting Rights Act, the literacy tests, the grandfather clauses, and so forth. Scholars, activists, Congress, and the court all understood that each device was just a new manifestation of this same ongoing effort. This was not interbranch dialogue. This was, in the words of the court, unremitting and ingenious defiance. So jumping off from that familiar example, this project then offers three case studies of contemporary disputes in which lawmakers, state and federal, executive and legislative, repeatedly suffer defeat in federal court and then go back to the drawing board, producing a subsequent version that is again challenged and scrutinized. So the three case studies that I use here are North Carolina's efforts to require photo identification and to restrict a variety of voting practices like early voting and same-day registration, which were disproportionately used by Black voters. So North Carolina has a long chronology, but a pivotal point for my case study is 2013. The General Assembly requested and received racial data on a whole host of voting practices, and then enacted omnibus voting restrictions that, in the words of the appellate court, targeted African Americans with almost surgical precision. So the case study follows the development of multiple rounds of challenge and reenactment. The second case study concerns Iowa's similar levels of determination to pass an ag-gag law, so-called measures that criminalize undercover investigations and whistleblowing in agricultural facilities. And the third case study, a much more high-profile one, is President Trump's persistent and ultimately successful efforts to impose a so-called Muslim ban. So I don't want to get too deep in the weeds here, but in the paper, I try to include enough factual and chronological detail to make the descriptive point that within each context, there was a singular trajectory of lawmaking effort, that we should view these as iterations in the same ongoing struggle, rather than a series of standalone single stage efforts. So you might ask, well, how is that done? How do you make that descriptive point? Well, using factual details, right? So time elapsed between a judgment striking down an enactment and subsequent iterations, the lawmaker's own statements critiquing the judicial opinion and announcing an intention to persist with a new version, continuity and expressions of legislative purpose, right? And then also honing in on legal details, right? Comparing the versions to each other and to the intervening opinions, and trying to surface that dynamic feedback effect that this area of constitutional struggle really demonstrates. So courts that have been called upon to examine the second or third iteration have understood that the inquiry should include some assessment of the relationship between the new effort and the previous invalidated one. So in the words of the Fourth Circuit, examining the lower court's undertaking of just that inquiry, the case comes down to one simple question, the appellate court says: how much does the past matter? As you'll see from the draft, I think that's putting the finger on the scale a bit. I think that it's more accurate to ask, how do we know the past is really past? And one of the things that I wanted to do in this article is to show that the answer to that question will eventually become outcome determinative as government defendants learn how to conceal the defects that were fatal to prior versions. One of the things I think the case studies illustrate is that constitutional litigation is information forcing in a way that works to the benefit of government defendants who are determined to stay the course. Right. So I think one of the insights to glean here is that we should expect that subsequent iterations will be sanitized of the offending elements and superficially compliant with constitutional principles. And so this presents a conundrum for courts that are reviewing these subsequent iterations. Do these changes reflect some sort of authentic recalibration, a real reshaping of policy preferences to accommodate the constitutional principles announced by the court? Or does the appearance of neutralizing elements in later stages indicate merely a strategic adaptation meant to conceal an illicit purpose, an ongoing illicit purpose? So one of the descriptive goals of the paper is to try to chronicle these strategic adaptations across various areas of constitutional struggle to better understand and manage them. Again, the key point is that courts will eventually be presented with laws that have been scrubbed clean of their most obvious flaws, and that these sanitized versions may very well have passed muster had they been the lawmakers' first attempt at the issues in question. But the real pressing, recurring analytical question is, shouldn't the analysis of the latest version take into account the entire sequence that preceded it? Now, as illustrated by the three case studies I use here, a central piece of the puzzle concerns the intent that's underlying the challenged law and its successors. So where intent is constitutionally significant, as it continues to be in so many areas of constitutional law, notwithstanding a robust scholarly literature that critiques this endeavor, right? All of that is stipulated. But intent continues to be a huge part of some key doctrinal inquiries. And so the question is for courts, how should this original impermissible intent be traced through subsequent efforts? How should we assess whether that impermissible intent lingers covertly, right? The lawmakers in question may have heeded the admonishment from the court and avoided an open restatement, but what can we do about our concerns that the new version may simply be a fiction or a fictionally cleansed work product, right? So lots of methodological questions here for the courts that are reviewing these subsequent efforts. How long does impermissible intent linger? Whose burden should it be to establish its presence or absence? So here's where we're teed up to talk about the second goal of the paper, which is to discern what guidance the court has offered on these questions. And one of the things that I wanted to do is show that its approach has been changing, but without acknowledgement of the significance of these changes. The starting point, as everyone recognizes, is Arlington Heights, right? The framework that the court has offered for plaintiffs who are assessing a superficially neutral law and attempting to demonstrate that there's impermissible intent. Everyone recognizes that Arlington Heights provides the overarching structure, but from there, the clarity diminishes. The court at one point was highly sensitive to the idea that a contemporary, facially unproblematic law might nonetheless contain, quote, unconstitutional remnants if it was traceable to prior unconstitutional conduct. It went so far as to place the burden on the state, given an initially tainted policy, to show that the link between the new law and the prior version had been severed. That's Fortis versus United States. In a subsequent case, McCreary, while not applying an explicit burden shifting framework, the court expressly took into account, over the defendant's objections, the evolution of the challenged policy, not merely its latest iteration. As the court there observed, the world is not made brand new every morning. Reasonable observers have reasonable memories. More recently, however, specifically in a case called Abbott versus Perez, the court has cautioned against treating past discrimination as a sort of original sin that continues to taint subsequent lawmaking, and really chastised and reversed the lower court for disregarding, quote, the presumption of legislative good faith. So within this part of the project, there's a nested argument that Fortis, McCreary, and Abbott have application beyond their doctrinal silos of educational segregation, 10 Commandments in courthouses, and redistricting. They, in my view, comprise a branch of the Arlington Heights progeny that specifically concerns iterative lawmaking. What inferences can and should we draw from prior versions of a challenged law? What is the appropriate methodology for approaching these questions? The third goal is to critique the recent turn. And since we're running short on time, and independently, any detailed discussion of Abbott versus Perez on a Saturday is probably not something that I would wish upon colleagues, maybe not even my worst enemies. We'll maybe skip over this point and save it for the Q&A. The short version is this: Abbott versus Perez, whatever its shortcomings on its own facts, had a really unusual procedural history that made the presumption of legislative good faith much more reasonable in that context than it is in others. We're already seeing Abbott being applied beyond these contexts in ways that really threaten to emerge into a presumption of legislative good faith that's one that's infinitely renewable, no matter what has gone no matter what has happened in the past, no matter how many times the state has attempted to refashion its prior work product. The argument here is that to treat the presumption of legislative good faith as an infinitely renewable resource is really to undermine the substantive constitutional disputes underlying these multi-phase disputes. In equal protection, in free speech doctrine, in litigation over religious liberty, in all of these areas, the court has been consistent that sophisticated as well as simple-minded modes of discrimination are equally invalid, right? Illicit motive, whether overt or disguised, need to be rooted out. And so in sum, the persistence and the strategic adaptations that we see in the case studies reported here really suggest that fidelity to these substantive principles requires a convincing approach to second bite lawmaking. So with that, I'll pause. I look forward to your questions and comments in the Q&A, and of course to hearing from my fellow panelists.
Thanks, Rebecca. Deborah, you're up.
Okay, can you hear me? Yes, excellent. Okay, great. Let me first thank all of you here, and especially Maggie and Shalev and Andrew, who helped organize the conference. It's great to be here. I wish we were actually physically in Arizona, but here we are. The current working title of my paper is called Lawyering the Presidency. And in the current context, the Trump presidency, beginning really from the moment of his election, I think triggered this renewed and intense focus on what has been a longstanding but still unsettled debate about the ability of law to, the word we usually use is constrain presidential power, whether the laws are anti-corruption rules or laws regulating the use of military force. In the scholarship leading up to Trump, which had really blossomed post 9/11 and the sort of John Yoo OLC era, the scholarship leading up to Trump, which was mostly theoretical, and leavened to some extent with particular anecdotal examples of how counsel influenced or did not influence presidential decision-making one way or another, was deeply divided, and most especially divided on the role of presidential legal counsel. And when I say in this context, presidential legal counsel, I mean some combination of one or more of OLC or White House counsel or any of the relevant senior legal counsel, which is varied across administration, which is providing this sort of relevant legal advice to decision makers. And I wondered, looking at this scholarship and trying to think about it in the present context, whether it was possible to test empirically and more systematically than in this sort of anecdotal ways, whether, as some scholars were claiming, counsel really functions to leave the executive, the president, and executive decision makers unbound by law or functionally unbound by law, or whether counsel is actually part of what other scholars have called, like Neil Katyal calls, the internal separation of powers. That is, functions at least at some level to, again, the word constrain power, especially in areas where Congress is relatively quiescent because of political polarization or otherwise, and the courts are largely silent, either because generally deferential or because the questions of law never end up getting litigated in courts one way or another. So the study I conducted, which is a qualitative empirical study, surveyed more than 36 senior national security policy officials who served in the two pre-Trump administrations, so the George W. Bush administration, the Obama administration. The officials ranged from the cabinet secretary level at the most senior to the senior director level on the National Security Council. Senior directors are sort of mid-level to relatively senior staff on the National Security Council responsible for different issues. And the study, which I'll talk about here for a bit, suggests that, in fact, counsel exert an extraordinary degree of influence over policy decision-making, and did in both of these administrations, or at least among the officials surveyed from both of these administrations. But their influence, I argue, is far more complex than simply acting as a constraint. And part of the reason is because this term constraint has been, I think, used and misused and was not, in fact, what I tested. But by way of sort of introductory summary, let me say, to the extent that constraint and the search for legal constraints mean that legal counsel is capable of changing preferred policy decisions as a result of law or the application of law, my study certainly finds evidence that policy officials seek counsel's advice early and often, that counsel is deeply integrated into the policymaking process, that counsel's advice sometimes surprises officials, that counsel have said no and have had those no's attended to by policy officials in the context of particular initiatives. And so I think there is ample evidence to say that the most negative case, the executive as unbound by law or legal counsel, is not right. But to the extent that reformers concerned about constraint are interested, and it is certainly the sort of current discussion, are interested in limiting the substantive scope of executive power. That is, interested in counsel's ability to make it more likely that policy officials exercise or assert less power rather than more. The study raised the prospect that our current understanding of the sort of council policy official legal dynamic, in which policy officials constantly want more power and greater flexibility and less interference by law, and council are at pains to try to provide them that flexibility, that description of the relationship dynamic between council and policy official is not right. Among other things, the study raises the prospect that council's guidance, when it is, as it sometimes is, more permissive than what policy officials' baseline normative instincts might assume or prefer they should do, that council's advice might serve as an incentive to avoid engaging external checks, for example, Congress or the UN Security Council regarding the use of force, when officials might otherwise decide that they would substantively prefer as a normative matter to seek it. So that's a quick thumbnail of the sort of project and what sort of an overview of the findings. Let me, in the minutes I have here, do just a couple of things. I want to give you a little bit of background about the ongoing debate, so the scholarly background against which and within which I'm writing on this conversation. I'll say a few words about methods, and there is an enormous amount to say about methods. So I'm happy to talk about that at length at some point if folks want. And then I'll say just a little bit more about some of the findings. And there are a great many that I think are interesting, but I wanted to limit, for purposes of time, the scope of the discussion here. Okay, so this literature of legal constraint, there is, as I'm sure most of you know, a vast scholarly literature, both in law and political science, that inquire one way or another whether law is capable of constraining state power, and in particular high power, like state decision-making or official decision-making in these rarefied political realms involving questions like the use of military force. Among legal scholars, the focus of this literature has often been on the operation of particular legal structures, so the courts, for example, but more commonly, because particularly in questions surrounding the use of force, Congress is often silent or acquiescent, and the courts have in various ways left core questions of sort of substantive scope of power open. A large body of this literature has focused on structures within the executive branch, and the extent to which these structures might operate as a sort of internal check capable of providing its own constraint on the legality of executive power. And I am now going to grossly oversimplify and summarize what is a pretty rich and diverse literature. But I think for present purposes, let me suggest that existing scholarly answers to this question have come in roughly one of three flavors, right? One answer, and so folks like Posner and Vermeulen have a book that suggests this answer is, look, these internal executive constraints or these internal executive branch structures, whatever they think they're doing and whatever the current state of the substantive law, are simply ineffective and substantially irrelevant in guiding presidential or even executive official decision-making in this realm. That's one answer, and they're not the only ones who give it. I think that's, if I had to point to a conventional answer, I would say that might be it. A second answer is quite different, and you can find it in the works of folks like Neil Katyal and Trevor Morrison and Laura Dickinson, who've done some combination of theoretical and sort of qualitative empirical studies, who all argue, in fact, counsel can have a significant constraining effect. Now, they use the word constraint in different ways, they use different words, but the upshot is that counsel's view, counsel's advice matters in particular contexts, and that counsel are capable of saying no to the executive and to having that no answer taken seriously and to changing policy action. A third species of the existing literature would say, I think rightly, that we should stop asking, and I am now characterizing, this is not what they say in so many terms, but they say, I'm not sure the question of constraint is the right answer. And so is the right question to be asking about counsel's role. They ask, taking the problems of legal advice like the advice John Yoo provided in the so-called torture memo in 2002, other examples, including most recently the role of Trump's own White House counsel and other legal advisors inside the White House. So folks who have worked as executive branch lawyers, but are now scholars like Daphne Renan and Jack Goldsmith and Bob Bauer have writing on this, and Mary DeRosa as well, that what we should really be asking is how to ensure that counsel's advice, which they take as a given, matters, is of the right quality, is the best possible advice that counsel can provide, and how should we structure those internal offices to make sure that counsel at least avoids the sort of ethical disaster that is that for which John Yoo is held up as the sort of, John Yoo's memo anyway, is held up as the sort of poster child. So to the extent this literature has had an empirical basis, I argue in my paper and here that they suffer from several flaws that made me sort of be unsatisfied, the sort of range of answers that were provided. For one thing, to the extent, again, they have an empirical basis, the empirical basis is based almost entirely on conversations with and articles by executive branch lawyers. So empirical studies that have been conducted that interview 20 different lawyers who've served in different legal offices or in one different legal office. And these perspectives are invaluable and incredibly informative and helped guide the study that I was doing here, but they are simply inevitably skewed, both because one might worry that executive branch lawyers have particular expectations or assumptions about the significance of their own role or the nature of their own role. And of course, because it only speaks to one half of the lawyer-client relationship in the policy context. The other critique, which I foreshadowed here, is that they've been conceptually quite vague in their inquiry. So most of them search for some sign of constraint, but some of them take the word constraint to mean any indication that officials care about and may change their course of action if they are instructed that that course of action is inconsistent with law. But many others use the term constraint, and sometimes in more than one ways, to require a showing that officials are limited by particular relatively narrow or relatively narrower interpretations in an area of contested law. For example, the circumstances in which the president has to first get congressional authorization before using force. And the final problem with constraint as a sort of mode of inquiry is that it tends to be, or has had the effect of being, relatively tendentious. That is, it implies in either species of the meaning of the word constraint that lawyers are functioning, if at all, as something like an on-off switch, that the way in which they exert influence is to say yes or no, and that in fact, this is the only way in which one might perceive legal influence one way or another. And I think that from the outset excludes the prospect that there might be even any slightly more nuanced forms of influence. Okay, so what did I do here? I did a couple of things in these interviews, and I gave officials the option of taking an online, fully anonymous confidential survey or doing an in-person, also confidential interview sort of directly. The interviews were all conducted in the pre-COVID universe, the in-person interviews that is. To get at the first species of the constraint question, that is where constraint means law has the potential to be a deciding factor, I looked for evidence that policymakers had what HLA Hart would have called and did call an internal sense of an obligation to engage counsel's advice. Did they believe they had to consult counsel before undertaking a particular decision? Did those consultations come at meaningful times, that is before key decisions in the policy process had been made? Did counsel's guidance, did officials ever get guidance from counsel that surprised them, which suggested they were asking questions to which they didn't already know the answer for sure? And of course, did counsel's guidance ever actually forestall an otherwise identified and preferred course of action? So that was one set of questions that I asked. A second set of questions that I asked were designed to get at a more substantive form of constraint, the more substantive meaning of constraint. That is, whether or not and when legal guidance in this realm might make officials less likely to use force or more likely to engage external constraints on decision-making, more likely to seek congressional authorization, to seek UN Security Council authorization. And to do that, I wanted to get at officials' independent normative beliefs implicating particular substantive questions of law. I didn't want to ask officials what the law was. I wanted to ask them, in particular circumstances, what would your normative preference be of what to do? So I focused on a couple of particular questions, three: whether or not the president should, in all things considered, in their view, notify Congress of a planned use of force, seek congressional authorization for use of force, or seek UN Security Council authorization before a use of military force. And I did it in a series of hypothetical circumstances that were designed to expose, as if I were writing a law exam hypothetical, different underlying questions of law. And by then comparing those baseline normative preferences that I learned from officials to the advice that they would have received from counsel at the time, for example, that no UN security authorization is required when a foreign state has consented to the use of force, right? I hope to learn something about how and in what substantive direction a counsel who was sufficiently influential might function to move officials off their pre-existing normative preferences. So there's a lot to say about findings, but in the interest of time, let me limit it to just a few things. First, on the question of the HLA Hart question, was there an internalized sense of an obligation to engage legal counsel? In the strongly bipartisan group that was surveyed here, the officials' commitment to engage meaningfully with legal counsel, I think the clearest finding of the study was deeply internalized. It was consistent across the political spectrum and generally the same, whether the underlying legal question emerges from statutory or constitutional or international legal instruments. Counsel was deeply, if somewhat differently, integrated in the policy process in both administrations I studied. They were commonly described by policy officials as part of the same team, by which they meant part of the same administrative, collegial, political team. Counsel served a wide range of functions and advised the group of policy officials they were advising were deeply dependent on their advice for a variety of reasons, not only because of the team dynamic that I described, but also because this group was, notwithstanding their senior status, relatively unfamiliar with even sort of the most basic legal rules in the applicable field, or at least some significant chunk of them were. As one very senior official put it, and this was one of my favorite quotes, I'll just use this as an example here. My rule was, he said, never in the Situation Room without a lawyer, right? So it was simply inconceivable to this group of officials, again, Republicans and Democrats and independents alike, that they would not engage counsel in a meaningful way in use of force decision making. About half of those I surveyed had the experience of counsel saying no, had the experience either of being surprised by counsel's advice after having asked for it, or had the experience of counsel saying no. But that half doesn't even fully capture the extent to which the half that had that, and it didn't break down naturally on political or other identifiable lines. When I asked, have you ever had the experience of counsel saying no, the answers to the people who said no were something like sure, or all the time, right? So there was simply no question. What then can we say about how this degree of influence operated on policymakers' normative preferences, right? Were they more likely to expand or contract, make it more or less likely that the executive would actually use force or engage outside constraints? And here, I think what might be most interesting to me is the extent to which the standard story of the counsel-client relationship in the executive branch fails to capture the range of potential decisional dynamics. So the standard story of the counsel-client relationship, I think, or the common story is, policy officials seek maximum policy flexibility from counsel. They are reluctant to go to counsel unless they're certain they're going to get an answer yes, and that counsel therefore feels pressured to provide, either directly pressured or from their own sense of role, pressured to provide maximal flexibility, the broadest understanding of the scope of executive power. But in fact, there were a number of examples that my study unearthed that suggest that is certainly that while that is sometimes the case, it is certainly not always the case. So just one example here, and then I'll conclude. A fraction of the officials I surveyed believed, as a normative matter, that the US should seek UN Security Council authorization for any use of force against a foreign state, even if that state had consented to the US use of force on their territory. That is, the policymaker's normative preference would be, let's engage additional checks on US action or US use of force. Now, the guidance they would receive from legal counsel, which would be delivered in real time by a highly trusted legal advisor, would inform them accurately, right, as a matter of law, no such authorization is required. In those circumstances, for those decision makers, I hypothesize, the availability and indeed trustworthy availability of permissive advice might tend to make it more likely for the official to support a use of force without an additional external check. This is not at all to say that legal advice under those circumstances is wrong, but it is to say that in this example and some others that I discuss in the paper, legal counsel is capable of disabling or has the effect of disabling otherwise accessible or available constraints on presidential action. For reformers interested in ensuring simply ethical baseline quality of legal advice, this example should be of no concern. Counsel's advice is surely correct as a matter of law. But for reformers, and many reformers are, interested in redesigning counsel's role to maximize counsel's effect as a substantive legal constraint, that is a substantive limit on the scope of executive power. The range of decisional dynamics implicated in counsel and officials' role, I think, suggests the need to consider a different range of reforms to the role of legal counsel than those, for example, like transparency and qualification requirements that are typically considered. I think I'll stop there and welcome questions later.
Thanks, Deborah. Alan, you're up.
Great, thank you. Let me just share my screen quickly. So yeah, thanks everyone. Can everyone see the screen? Great. So right after I submitted this conference draft, I saw this floating around Twitter, and it really hit home. This is a project I'm excited about. I want to make it a big project. I think there's potential for a lot of growth, and right now it's a little horsey on the right. So I look forward to everyone's guidance here. So let me take a minute just to explain what it is that got me thinking about this, because I think it might be helpful in situating the somewhat abstract conception of Article 2 that I put forward. So shortly after Trump's inauguration, and let's be honest, all throughout the 2016 election, there were concerns, not just about sort of what kind of policy he was going to have, but his fundamental fitness for office. And I think this is captured really nicely in this post from Lawfare back in March 2017. What happens when we don't believe the president's oath? The idea here being that what happens when we've elected someone who, for various characterological and psychological reasons, we're not sure is even capable of honestly and faithfully swearing to oaths, let alone anything else. And this got me thinking, something I've been thinking about for several years now. It got me thinking about a kind of a previous set of interesting conversations back in the 2000s around what constitutes a constitutional crisis. This great piece by Levinson and Balkin, but there are a bunch of these floating around. And it occurred to me that, or my intuition was that we might be living through a constitutional crisis of sorts. Now, the constitutional crises that we're most familiar with are acute crises, things like the Civil War. But there can be things like what I call chronic crises, where for potentially long periods of time, the political system can continue chugging along, and yet in some fundamental way, the Constitution is being violated. The best example of this is the 100-year period of Jim Crow after the Reconstruction amendments. And I could not shake the idea that what we were seeing between 2016 and now 2021 was not simply bad policy or bad administration, but was something potentially more serious. My development or my attempt to frame, or my attempt to create a language using virtue ethics to talk about Article 2 is a way of taking this intuition and trying to make it more rigorous. Now, whether or not it's convincing, I'm not sure. I think there are actually a lot of really interesting and important objections to my account. But my goal kind of in this initial attempt is just to build a language that is sort of coherent and can help us communicate better about this. So what do I mean by virtue theory of Article 2? Well, let me start with what I mean by virtue theory in general. Virtue theory is an approach to moral philosophy. It's quite old. In a sense, all moral philosophies going back to the ancient Greeks, and then of course other traditions have their ancient traditions as well, are types of virtue theory. So you have Aristotle, most famously in the Nicomachean Ethics, puts forward one But for various reasons, virtue theory as a way of doing moral philosophy diminishes in importance, especially in the early modern and modern periods, and it is replaced instead by deontological traditions like Kantian ethics that are really focused on rules, and then utilitarian traditions that are focused on outcomes. This changes in the mid-20th century with the very famous article by the philosopher Elizabeth Anscombe called Modern Moral Philosophy, where she tries to bring this back. And ever since then, in academic moral philosophy, virtue ethics has been one of the three main approaches. Now, we haven't seen a lot of it in legal theory, which is still dominated by either kind of Kantian rule-based conceptions of law or by utilitarian outcomes-based conceptions of law. But there's been really important work done, in particular by Larry Solem back in the 2000s, trying to come up with what a virtue-centered theory of judging would look like. And so my paper is very much in that tradition, but instead of looking at what virtuous judging would look like, I'm looking at what virtuous execution would look like, what a virtuous president would look like. Okay, so what are the main components of any virtue theory? There are lots of them, but they, I think, all share the same common methodological commitments. The first is this definitional idea that what a virtue and what a vice is, which is the opposite of a virtue, it's a disposition to behave in a certain way. It's a complex combination of both cognitive and affective or emotional qualities that make someone, for example, want to be honest, want to give the honest answer, right? That's what it is to have the virtue of honesty or to have the vice of dishonesty. Now, what is key here and what makes virtue ethics, I think, so important is that it posits that virtues are explanatorily prior, which is to say, it is not simply the case that we identify what honesty is by first having a conception of what honest action is, and then looking for characteristics common to people that make honest actions. Rather, at least in some cases, we don't actually know what the honest action is. Instead, what we know is that there are people who are paragons of honesty. And so in certain cases, we look to them to tell us what it is to be honest, right? So this is, I think, the key conceptual point of any virtue theory, whether it's an ethical one or a legal one. It says that the virtue is explanatorily prior and more foundational than, let's say, the virtuous action. So there's a couple of consequences of that. Virtue on this conception is not a decision algorithm, right? It cannot be reducible to simply a set of rules, otherwise it would not be explanatorily prior. In particular, virtue requires first practical wisdom, or phronesis, as the ancient Greeks would say, and this is the ability to have a very context-sensitive approach to figuring out what the right action is in any particular case, in a way that cannot be reducible simply to rules ex ante. And second, that one way, and an important way, that we learn about what constitutes a virtue is by looking at virtuous exemplars, right? So when we're trying to figure out what is the honest thing to do, we think of, well, who are the honest people in our imagination? Let's say honest Abe, right? Or what is the courageous thing to do? And we think, well, who are courageous people? Well, Joan of Arc was courageous. What would she do in this situation? And this is, in fact, psychologically how it is that we give a lot of content to our virtues. Okay, so that's virtue theory generally. What does a virtue theory of Article 2 even look like? Well, it actually maps, I think, pretty naturally. So the first thing is that, and this is, again, to the extent that there's sort of a key conceptual thesis in this paper, it's this, that at least in certain cases, the virtue or vice of the executive at issue is a fundamental component in explaining and constituting the legality of that executive's action, right? That the personal characteristics of the executive matter in a very deep way when we're trying to figure out whether or not the exercise of the executive's discretion was legal under Article 2, right? Similarly, virtuous executive exemplars play an important role in trying to figure this out. So that, in fact, a lot of what we think of as looking at historical practice is looking at historical practice of specific exemplars, right? So we might look to, let's say, Washington or Lincoln to figure out, what is the appropriate scope of executive to power. Similarly, we might look at Nixon or Andrew Johnson for the reverse, right? Okay. And then finally, what makes virtuous Article 2 action cannot be simply, it's not simply a matter of some pre-existing legal rules. And I apologize, I think there's a typo in this slide. But it's impossible to sit down and simply write, here is what would under any president constitute virtuous action. Okay, so what then are the executive virtues? Here, I'm just going to provide a tentative list, but I think the specifics here matter less than the kind of intuitive plausibility of there being one that we can mostly agree on. So faithfulness, obviously, loyalty and selflessness, right? Putting the interests of the country, of the nation, of the polity before one's own interests. Deliberativeness, and Shalev, who's here, has done a lot of really good work on the role of deliberateness in Article 2. Prudence. We could come up with a long list, and that's part of what I want to explore. But I want to, for a moment, bracket what the exact virtues are and assume that there is some minimal set of virtues that most of us can agree on most of the time. Okay, so what's the point of all of this kind of apparatus that I'm trying to build up? Well, I think one benefit is that it provides a useful set of interpretive approaches for thinking about Article 2. So for example, I think it does a nice job of illuminating something in the original understanding that is often left out, which is the strong Republican tradition in which the framers are operating, right? A Republican tradition that goes all the way back to Renaissance Italian political thought, and then all the way back to Rome and all the way back to Greece, right? The idea here being that Madison and the rest of them were suffused with the idea that you needed public virtue among the people, but also public virtue among the officials, and that it was not simply enough to create structures to separate and check power, but you needed to have the right sorts of people in those roles. And I think that is something that we as constitutional theorists have spent less time talking about lately than we should have, and that virtue is a nice way of getting back to that. I think it also explains some features of Article 2 of the text itself. It explains, I think, partly the open-ended nature of Article 2, why Article 2 provides so little specific guidance to the executive. I think part of that is because there's an assumption that the executive will have the sort of virtue and the sort of practical wisdom necessary to figure out what to do in a particular circumstance. I think it's part of what explains why there's this focus on faithfulness, both in the Take Care Clause and in the Presidential Oath of Office Clause. I think it's part of what explains why so much of Article 2 is devoted to selection procedures. The president must be 35 years old. He must be a natural-born citizen. The whole electoral college complex process is in part an attempt to weed out non-virtuous executives. So I think interpretively it is a useful language. I think it's also normatively better than our current language. And here I want to give a couple of examples of where I think that benefit comes in. So doctrinally, right? And here, the example that I thought of was Trump versus Hawaii, and listening to and reading Rebecca's discussion of second bite lawmaking, I think this naturally connects quite nicely. You have second bite executive action, right? In Trump versus Hawaii, the court says it doesn't matter who the president is. All that matters is what the executive order says. And I think a focus on virtue gives us really powerful language to push back on that and explain partially what's so problematic about the whole Muslim ban saga. I think it helps also with certain frustrations that I think a lot of us had, whether it was in the Mueller report or during the second impeachment, with this obsession on the use of criminal law language as the main way that we decide whether or not, let's say, President Trump was doing the right thing. This obsession with what constituted collusion. This discussion of, well, was it incitement under the Brandenburg standard when they did the Stop the Steal rally or not? Instead, we move away from that and we can focus on something more general like the virtues. I think we have a better and potentially more richer constitutional discourse. And then finally, I think maybe this is the most important part. It's part of public constitutionalism. It's part of what I think voters should think about when they throw around terms like, well, that was disqualifying. Right? What does disqualifying really mean? Now, I'm not so naive as to think that the vast majority of voters are going to sit there and ponder deep thoughts about the Constitution before going into the ballot box. But in a highly polarized system, right, in which elections are decided by potentially half a percentage or percentage here or there, I think injecting that language can be useful, right, in just another tool we have to push back against unvirtuous executives. There are tons of serious objections to this, right? I'm well aware that I'm deeply over my skis here. So an incomplete list, right? So insufficient guidance for presidents and their lawyers. And here I'd be really curious what Deborah thinks about how a lawyer in the executive branch told to ensure virtuous action, what would they do? Right? Excessive personalization. Do we really need to spend even more time focusing on the personal characteristics of the president, given the increasing imperial nature of the office ever since Roosevelt? Destabilizing democracy. Do we need a language of constitutional bad faith to echo something that David Posen has written about, do we need to start making arguments that this president was illegitimate from day one? These are all very serious objections. I think I have answers to them, but and I'm sure there are others, but I wanted to flag them here. So let me then, in the last minute or so, go back to the beginning and try to use this apparatus to help talk about what is it that we just lived through. And so this is what I think we just lived through, right? I think that the Trump 4 years was not merely a very unpleasant, unfortunate time in American politics. I don't think it was merely a series of constitutional violations. I think it was one long constitutional violation because the person we elected was not fit for office, lacked the necessary executive virtues. And just as if Trump had been 30, if Trump had not been a natural born citizen, we would say, well, there was an ongoing constitutional violation. I think that this is the conclusion, and I think it's a somewhat radical conclusion, but for me, it is becoming increasingly inescapable as I think about this. And that I think the language of virtue and vice allows us to better understand what happened, to better talk about what happened, and since every legal project has to be normative, and to better fight against what happened. So thank you very much, and I'm really looking forward to you all ripping this apart.
Thanks, Alan. So that makes me be up. I'm going to try to talk fast. There's a lot to get through. While I'm chattering on, if anyone has questions, please feel free to type the letter Q into the chat, and that's the way we'll keep our Q. So each of these is a fascinating project that raises so many questions. I'm only going to be able to scratch the surface. I'm going to take them in the order that you all presented them. So Rebecca, let me start with you. I love the idea of focusing in on this phenomenon of sort of fixer laws enacted in the wake of a constitutional invalidation. And I thought you might want to zero in on it even more than you already do. So your examples all involve two features. The first being the fact of prior legislative or executive action on the same topic. And then the second being all the stuff the legislators said or lawmakers said or otherwise indicated about their motivations at some point in the course of the lawmaking process. Now, as you know, there's no shortage of commentary on that second feature on, how to discern the motivations behind a particular piece of law, whether individual statements should matter, and so on. And so I think it would be helpful to say more sort of constantly in your paper about why the first feature is really important. That is why it matters that there's actually a prior version of this law that was struck down by a court. And I thought the Iowa ag-gag law might be a good example for drawing that out. So you note that the later versions of the law showed, an apparent responsiveness on the part of the legislators to the constitutional problems that courts had identified with the earlier enactments. But then also that the legislators continued to be surprisingly and, maybe foolishly candid about their motivation to target the animal rights movement. So, suppose the legislators had said all those same things, but had not enacted the prior version of the law. How exactly would the analysis be different? Or what do the earlier enactments add to the inquiry into purpose or motivation? And I flag this in part because I think there could be an argument there, in addition to the ones you already draw out in the paper, that would sort of play a bit off skepticism about whether it's possible or wise to try to glean collective motivation from the statements of particular legislators, and really emphasize the fact that, there was a prior enactment here that garnered majority support, went through the whole legislative process, including the possibility of the executive veto, and that makes this a different and stronger case than it would be if we just had a single law along with some damning statements in the legislative history. Then, of course, the challenge would be to translate that kind of argument to something like the travel ban, to explain why the fact of a prior formal executive action would be meaningful when we're dealing with a unitary actor like the president. Relatedly, I think it would help to be more explicit about why it matters that the prior iterations of the law were invalidated, as opposed to simply there and then changed in some way, just amended. As you say, a big source of the concern about second bite lawmaking is that the process of constitutional litigation, sort of gives legislators a roadmap for how to dress up constitutionally suspect laws in ways that might hide their flaws. I would do even more to draw that out because it helps distinguish your thing, second bite lawmaking, from the far more general challenge of how to understand new enactments and amendments in light of what's already there. So one example I kept thinking about as I read your paper were constitutional challenges to statutes mandating a moment of silence in public schools. That's an example of the broader latter category. And we see courts in those cases drawing inferences about secular purpose or lack thereof based on what was permitted or required by prior versions of the law. So it's similar to your phenomenon, but different. And I think there might be some value to sort of drawing out what's different. Two other really quick suggestions. I think it would help a lot if you could find an example with a different political or policy valence. A series of legislative or executive actions that are seeking to satisfy some kind of constitutional rule that you are not as sympathetic to, and that your reader may not be as sympathetic to. And I say that in part because one place where I found myself disagreeing with you a bit was the suggestion that there's necessarily anything wrong or nefarious about lawmakers trying to nudge the law sort of just over the constitutional line, to do what's required by the court, but nothing more. I think that happens all the time in the law. And whether it's bad or not, to me, depends on whether I think the constitutional line is a good one. So like your Heller example, not as troubling to me. And so if you can find an example where you're actually more sympathetic to the lawmakers than you are to the courts, I think it'll help both you and your reader kind of stress test your intuitions about what's good and bad. Last, I do think it'll be really important to be clear about whether this kind of analysis extends beyond intent inquiries. That strikes me as really tough. And so one approach might be to just, you've got so much already in this paper, just limit this particular project to intent inquiries and save for another project thinking through extensions to other kinds of fields. Okay, Deborah, let me jump to you. So this is such a cool project. I love the idea of thinking about the role of government counsel by trying to learn a little bit about the client side. That's really insightful and unique, and I think it makes it a really powerful paper. So because of, I think, where I'm coming from in my own work, as I read your draft, I kept thinking to the point of distraction about similar debates in other fields. And so you alluded to that a little bit in your remarks about how these debates about the law's capacity to constrain are kind of all over the place. And for me, the version that I kept coming back to were debates about courts or judges. And I kept coming back to it because there are just so many of the same themes. And that made me wonder whether there might be some valuable threads that you could pull from that literature. So, a really common move, of course, is to argue that the law either doesn't or can't constrain judges unless we can find evidence of judges departing from whatever they would like to do as a matter of policy or preference. And then a very common response to that is to say that understanding of constraint overlooks how the law might shape preferences or how the law might provide a framework for decision, even when it's too indeterminate to compel a particular answer. There's just so much there that feels relevant to the questions that you're exploring. I thought it might be useful to dip in a bit, if only, to explain to people like me why we shouldn't get so hung up on the parallel. A second suggestion here, and maybe it's an audience question. I think a lot of your audience will be very familiar with the literatures you're intervening into, but you have a topic of such general interest that maybe not all will. And so for me, at least, who knew, some of the stuff you're referring back to and in dialogue with, but not all of it, it would have been helpful to frame more upfront the debates you're intervening in part because, as you mentioned in your remarks, they take different forms, right? There are sort of empirical or positive or descriptive debates about what counsel does or is capable of doing. And then there are there are normative debates about reform. And then there are these kind of conceptual debates about what questions should we be asking and how should we understand constraint. And those bleed into each other in ways that can be kind of confusing. And so it was most clear to me where you stood vis-a-vis the sort of constraint skeptics who are making positive claims about counsel's capacity to constrain, about whether counsel in fact does constrain. It was much less clear to me where you stood vis-a-vis reformers and others who are making normative claims about how counsel ought to behave. And so if it's possible to do this, I think it could be useful to give a couple examples of concrete reform proposals up front so that the reader has those in her mind as she reads all of the fantastic information you're providing and is able to be thinking as she takes that in, like, how does that make me feel, for example, about moving White House counsel out of White House and into DOJ? Relatedly, and just quickly on a similar point, I think it will be really important for you to be clear and precise about when folks are making positive arguments and when they're making normative arguments. And so one sort of foil that you're working against throughout a lot of the paper is the idea that counsel might just try to maximize policymaker flexibility by providing, sort of any colorable legal defense for whatever the client wants to do. And every time you said that, I wondered, does anyone actually argue that that's what counsel should do? Or are they just saying that's what we think counsel is incentivized to do, or what counsel often does? And so I would be careful to be really clear about that throughout. Okay, last thing, because I am running out of time, is about your proposal that counsel make the best case both for and against a proposed action, to sort of write the brief in both ways. I wanted to hear more about how that approach really would end up differing from the OLC approach of give the, quote, best view of the law. My own intuition, for what tiny bit it's worth, is we would risk diminishing the sort of advice giving capacity of counsel or role of counsel if counsel really did just prepare competing memos for both sides, but didn't say which argument was even marginally better, sort of like those exams we tell our students not to write, like plaintiffs will say, defendant will say. And so it seems inevitable to me that counsel is going to end up indicating a preference for one view over the other. But then I'm not sure how that cashes out to something meaningfully different from just a very well done statement of the best view, which, like any good legal argument, would take account of counter arguments and give sort of a thorough airing to counter arguments. Okay, Alan, let me start with superlatives here too. This is a fascinating project. I wish I had way more time to talk about it. And please forgive me if what I'm about to say reveals nothing other than my own ignorance about virtue theory. So first, a question about the scope of the theory, or maybe its application. At a couple times in the paper, you equate virtuous with lawful in a way that I think at the end of the day, you probably don't really mean. And so, I don't think at the end of the day that you would say that a presidential action that was otherwise plainly lawful, given a clear statutory authorization, for example, would be rendered unlawful by an unvirtuous disposition or unvirtuous motivations. And that makes me think the theory kicks in areas where legality is in question for some independent set of reasons. And as you develop the paper, I think that'll just be really important to clarify and sort of flesh out. So how much doubt would we need to have about legality in order for a virtue inquiry to be appropriate? And then how much weight does it get? Does it have? Is it a tiebreaker? Is it a presumption? Is it something stronger? So that's one set of questions. Another has to do with sort of methodology, in a sense, that is how you go about persuading someone to adopt your theory. And what would persuade you that it's wrong, or what should persuade anyone else that it's wrong? So early in the draft, when you're describing different kinds of moral theory, you have this amazingly clear and concise explanation that it's not possible to justify the axiomatic starting point of a theory. Instead, the best you can do is explain why your theory performs better than its competitors along some dimension of interest. And then you seem to apply that same approach when making the case for virtue theory as a constitutional theory. So you say the best way to argue for virtue theory is to show why it's more useful than the alternative theoretical accounts. So then that made me want to hear more about the alternative theoretical accounts that I should have in mind as I kept reading. Is it just, an alternate reading of the Constitution that just doesn't give a hoot about presidential virtue? Or that thinks, yeah, it'd be great, like we wish the president would be virtuous, but it's not unlawful if he's not? Or are there others that I should be thinking about as reader? And then, on the dimensions, how do you figure those out? And how do you do it in a way that avoids sort of just recurring back to an argument about whether we should care about virtue or not? So the second dimension you explore is checking executive abuses. But the million-dollar question is what counts as an abuse? And different theories or approaches are going to answer that question in different ways. And so as I read through that part, I kept thinking, how is this proving to me the theory as opposed to just demonstrating to me how the theory might cash out? And so I wanted more, I wanted as a reader to know more about sort of what test I should be applying as I read to figure out whether it had been satisfied or not by the particular examples. Okay, let me stop talking. We have a queue, so let's jump right to that. David.
Here, I have a question for Deborah. And Deborah, I appreciate all the papers. They're very interesting. I probably come at them from a somewhat different perspective than some of you, but most of you. But in any event, your paper seems to make the assumption, Deborah, that the lawyer is in the position of attempting to constrain an overweening executive. And but what about a situation that we all may be witnessing at present, where a President Biden speaks of unity and an inclusiveness and rejects the idea of dictatorial diktats, and while quite possibly being egged on to unconstitutional excesses by lawyers who should know better. Consider also how counsel to congressional officials may have urged those congressional officials to rush to impeachment in kind of these snap impeachment scenarios where they end up overstepping and getting called up short when they are asked to prove up a case for incitement to insurrection, which is a tough thing to prove, and any lawyer should have pointed that out, that was going to be extremely tough to kind of prove, even in a kind of a politicized setting. So I'm just questioning your premise. Your premise seems to be coming from the imagined, your view that this is all about President Trump being way over the line and pushing his lawyers to let him do something else. But speak up about that. Thanks.
Should I respond, Maggie, or?
I think it's up to you all as the panelists. So we do have some folks on the queue and we only have 9 minutes left. And so we could just take questions so that you can get as much input as possible and then I'm seeing a thumbs up from Ellen, and then use whatever time we have left at the end to respond if you'd like. So Deborah, you're actually next up on the queue. So you can go but in questioner.
Okay. Well, so great. And I will one way or another respond to David's questions because I think they're good. I think I want to later, I think I would love to answer Alan's very interesting question that he posed to me, but I think for present purposes, let me just ask Alan a question. And that is, so I wholeheartely agree with you, and I wouldn't have placed this at the feet of virtue ethics, about which I know nothing, but would have placed it at the feet of kind of traditional originalist constitutional history that the framers assumed and did a giant pile of things to maximize the likelihood that officials would possess a certain baseline set of virtue, right? So I am a baseline set of virtuous behavior and virtuous instincts. I could not agree more with your sort of basic claim there, and I think one could support it in a variety of ways. What I want to know a lot more about is what are the consequences that flow, what are the interpretive consequences that flow from the conclusion that an official or a government or a whatever you want to, you could just point to Trump or, whatever you want to talk about. What flows from the conclusion that this is not that this is not one of them? So I could imagine a lot of things. And one thing intersects really interestingly with Rebecca's paper in that, all of these presumptions that the law has, and one of the presumptions arises in this, sort of discrimination the context of anti-discrimination law, where you're supposed to assume good faith, right? So you get rid of those assumptions of good faith, for example, and those arise in a whole pile of doctrinal areas. But I want to know more in detail about the consequences for the legislature in dealing with a non-virtuous executive, the consequences for courts in dealing with a non-virtuous executive, the consequences for the American people, the voters in dealing with a non-virtuous executive. How does this impact the sort of dynamic mobile of the rest of the constitutional system when you've got this one skewed? Does it require that the whole rest of the institution warp itself out of its usual shape to address the illegitimate flaw of a non-virtuous official? Or is the better sort of constitutional outcome to try to retain the existing institutional structural commitments while, minimizing to the extent possible the sort of damage that might be done by a non-virtuous executive? So I have a pile of questions on that. I just want to know more, but I'm fascinated by the project. So that's it.
All right, I think we're officially in the lightning round now. Howard Katz.
Hi, my question is for Rebecca, who I haven't seen since basically you were a VAP on the market. So it's such a pleasure now to see how your career has developed. I don't want to be that person who says, write the paper that I wanted to write rather than the one you wanted to write. So this may be off path, but I'm wondering if there's anything to be learned or any comparison from the small literature at the level of state courts who have to decide whether a referendum that overturns a law and then the legislature comes back and tries to do something similar. We also have the example of Florida with DeSantis and the executive, the poll tax argument, the ex-convict argument. So I'm wondering if there's anything that can be learned, if there's any parallel, or maybe it's the next article about where it removes the issue of intent, of unconstitutional intent, because there was no original finding of unconstitutionality, but it has the common characteristic of the legislature trying to come up against some line that they've been told they can't approach.
Mark.
Okay, great. I'll be very, very quick. Mine is for Professor Rozenshtein. I'm very sympathetic to virtue ethical theories in the law generally, and I think they've got a lot to add as a sort of challenge to Kantian and utilitarian approaches. But I wonder, perhaps I want to add one of the additional objections that I didn't see on your presentation, and that is radical disagreement about what constitute the virtues, or what sort of concrete behavior rises to the level of a virtue or a vice. So virtue ethical theory, one of the problems with it is that it assumes a kind of moral universe that is relatively stable and not subject to the depredations of pluralism. And whether we are in a situation in this country today, in the same one that Aristotle was in ancient Greece, or even that the founders were in the 18th century, to be able to come together to agree might require its own set of moral and political theory building on top of virtue ethical theory. That is going to be a heavy lift. That's it.
Olive.
Thanks. I'll also try to be very quick. A lot of what I was going to say to you, Alan, I want to talk to you about more, but echoes what Maggie said about whether you're making a purely normative argument or you're making an argument about what the law is, and then how does that translate into external or internal enforcement of the law. But I'll talk to you about that offline. I had one thing I wanted to say that just kind of jumps off what Maggie said to Rebecca, which is I kind of wonder why it matters that it's enacted at all. And so one way to think about that is if the third version of the travel ban or Muslim ban had been issued without going through the 2 iterations, meaning those iterations had all happened internally within the executive branch, what would we do with that situation? Would it be any different? And if so, why? And if not, why not? And so why does enactment have anything to do with intent or the legal relevance of intent?
Kevin.
First, I want to thank Rebecca, Deborah, and Alan for their wonderful papers. I really enjoyed the panel tremendously. I have two quick questions, one for Rebecca and one for Alan. Rebecca, I kind of wonder about, I'm super sympathetic, and I think it's really such an interesting project. I wonder how much we should worry about, or how much you worry about in the paper, formal distinctions. Is it actually a new legislature that's been enacted? I sort of feel like if it's the same president, that makes a difference to me, as opposed to, at least there could be a formal distinction between two different legislatures enacted. So that was one little small question. And then for Alan, here I had a question about the extent to which Virtuous would be doing independent work from thinking about the executive as simply subject to arbitrary and capricious norms. Because I think that those capture a lot of what you're after, which is that you're thinking about the right considerations, you're weighing them in roughly the right measure, and you have the right kind of balance and goal in mind. So that was a thought, and there is a little bit of literature on that. Ganesh Sitaran has an article, and there's some others out there. So anyway, that was just a thought, but I super enjoyed all the papers. So thank you so much, and thanks for moderating, Maggie, and hosting all of it.
So we have a whopping minute left, but I think we can probably stay a little longer if for anyone who wants to. I know I would love to hear any responses the panelists have to what they've heard from everybody here. So I'm going to throw it back to Rebecca and Deborah and Alan for last words, if you'd like to give any real quick ones. Rebecca?
Sure. I'll start with a quick response to Shalev's point. I think part of the descriptive point that I'm making is that the subsequent iterations are responsive, either in an authentic, virtuous way or an evasive, strategic way to prior rulings. Now, I can still see that you might say, well, what if it's just a threat of a ruling? What if the president's lawyers sit down with the president and say, this is not going to succeed, right? Then I take your point that we might have a really similar phenomenon. It's just happening behind the scenes. But part of what I wanted to do is to show the feedback quality of these disputes. I'd like to engage with Kevin as well, but I think it would be better for me to pass off the mic to someone else.
Deborah, I think that passes to you then.
Okay, sure. There's so many great comments from Maggie, from you, and from others. So I guess let me, for present purposes, let me just respond to the, what am I assuming about the role that counsel is playing, and the sort of model I have in mind or thinking of. I don't have a particular model of counsel in mind. What I think I have in mind are a series of critiques and debates that have arisen in the last, say, 20 years about problems of the role of executive branch counsel. So one kind of problem and critique that has been made is the problem of really unethical legal advice, right? So in this category, the example that I was referring to, for example, I don't think it's the only one, but it's the kind of most prominent, is the John Hughes torture memo, right? So 50-page memo about whether or not the president has the constitutional authority to order an official to engage in torture, notwithstanding the federal criminal law prohibiting torture, that doesn't cite the Steele seizure case, right? So one might have a certain set of reforms one would recommend, including just changing ethics constraints on counsel to deal with that kind of a problem, right? But that's one problem that has arisen that reforms might want to deal with. But a second kind of problem is the problem of overly permissive advice. And here one might, and this is a concern that some, not all, but many reformers have, that is that while counsel's interpretation is plausibly within the range of ethical legal advice, it is way far out on one end of the distribution curve in terms of the breadth of power that it's asserting. And you can cite particular examples. You could cite an example from the Obama years, and I do in my paper, or you could cite Bob Bauer, who was Obama's White House counsel, who has subsequently argued that the standard for counsel shouldn't be what's the best view of the law. The standard should be, especially in exigent or emergency or use of force circumstances, what view is legally available, right? And in interviews and others, you could hear council talking about the incentive they felt to try to retain a seat at the table by giving the most flexible view, right? That's not their stated role, but they felt the sort of need to play that role, else they lose their ability to influence, right? So these are all the kind of critiques that I have that I think I should make more clear, that are floating around in my head that my piece is trying to engage with. Not some assumption that any one of them is necessarily right, but that these are problems and critiques with meaning that need to be addressed.
Alan, take us home.
Thanks, everyone. Immensely helpful. And I really appreciate a combination of serious engagement and being nice to what is clearly a super alpha stage project that is a lovely feature of this conference. So just to respond to something that Maggie said, and that I think connects to Mark's point about pluralism. Yeah, I think there's a big chunk here that I have to write down about what would constitute success, right? Or kind of methodologically, what is it that I'm assuming here? And I think the answer is something like reflective equilibrium. The idea here being that the Constitution exists for us to do things with. And so we take an approach to the Constitution, we see what it accomplishes for us, and then we see how many of those things do we like versus the things that we don't like. Now, one of the things that we like in our constitutional culture is originalism. Some of us may not like that we like that, but generally it seems that a lot of us like that. So this is why I think making sure that a virtue approach is at least consistent with originalism is important. But ultimately, and then this gets to Mark's point, right? Like I should just be explicit about this. I am relying on enough of my audience to share enough of my intuitions about what sort of country we want to live in, that they will then find this set of rhetorical and conceptual tools useful for them in their normative project, doing stuff with the Constitution, right? And so I think you're absolutely right. There's no way for me to prove that there's no way for me to prove that the right set of virtues is the one that excludes Donald Trump. But I'm okay not fighting that particular game. And the question then is, and I don't want to prejudge this, can I then find a set of virtues excluding those people that we can all agree on? I might not be able to, but I got my summer cut out for me at least. So thanks again so much. Really, really appreciate it. And if folks have other comments, I'd love to get them by email. Thanks so much.
Thanks, everyone. Great papers.
Thank you to the panelists and to Shalav and Andrew, although he's not here for organizing this. This has been a great event, and it's been just a pleasure to participate in it. I need to mute myself before I do that.